blow the whistle with EJLee Law.
Yo, whistleblowers, what's up? I'm throwing flags on the plays. I'm protecting your stuff. Welcome back to another episode of Blow the Whistle with EJLee Law. What do you guys think about my jingle? So I was in Michigan over the last 2 weeks. Unfortunately, my uncle passed, and I was there to celebrate Mother's Day. And while I was there, my mom and I came up with this jingle. And so again, I'm gonna say it one more time. So yo, whistleblowers, what's up? I'm throwing flags on the plays. I'm protecting your stuff. So you guys are my whistleblowers, and welcome back to another episode. This is episode 4, where we're talking about technical file number 4, design marks versus word marks. And again, on this channel, we're talking about the 12 technical files that I see most often in the IP game. So we're going to be doing a quick recap of what we've talked about so far, where we always start with, who is EJLee Law? EJLee Law Practice LLC is located in Metro Atlanta. We handle copyright and trademark registrations worldwide, adding patents soon, as well as drafting, reviewing, and negotiating contracts for members of the entertainment industry and Georgia businesses big and small. So just to recap, we've talked about technical file number 1. What is the purpose of a trademark? And the purpose of a trademark is to act as a source identifier for your company, whether you offer products or services. So go back to episode 1 if you'd like to see more about that. Technical file number 2, understanding the differences in IP protection. We've talked about patent, copyright, and trademark differences. Technical file number 3, understanding the purpose of a slogan or a catchphrase, also as a source identifier. Which brings us to technical file number 4, a design mark versus a word mark. Do you need both? A design mark is a stylized creative mark consisting of a combination of a stylized font, colors, symbols, shapes, or other creative elements. A word mark is a word or a group of words from the dictionary or made up with no particular claim of creative elements. Considerations. Do I like my design mark? Will I ever change it in the future? What's my legal budget if I have both and are using both consistently and continuously? Think about some of the most iconic brands that have design marks. Most of them have not changed in decades. Think of McDonald's, Taco Bell, Burger King, and then your more luxury brands such as Chanel, Coach, and any other luxury brand that you can think of where their actual logo has not changed much. If you plan to change your logo or do not have one, start with a basic word mark and you can add a design mark later. Big brands usually have both, but if you're a fresh business or you haven't been operating for long, start where you are. If your word mark is considered generic or highly descriptive, a creative design mark could be best. And this is something to consider, but always aim for uniqueness. Always. Got additional questions? Subscribe to our newsletter via our website at ejleelawpractice.legal. You can also email us. You can give us a call at 678-343-2799. You can also follow our Facebook page. You can follow our Twitter and Instagram, which are both at EJLee Law. We also offer affordable DIY courses under Referee Whistle Official, and the next one is taking place this coming Saturday, not April, but in May, and I will make sure that information is in the description box. And I will also give you guys a little taste of what the Referee Whistle Official is all about.
Hello, attorney EJLee here. Trademarks are the first thing that people recognize about your business. However, many startups and entrepreneurs do a limited budget delay the intellectual property registration process, which often leaves them legally vulnerable. Introducing Referee Whistle Official Live Webinar, an exclusive one-day event to get you off the idea sidelines and into the game. Referee Whistle Official Live Webinar is a monthly invitation-only event for entrepreneurs, brand builders, entertainers, authors, and creatives ready to dive into the art of intellectual property protection. Are you ready to register your trademarks but unsure exactly how to do it? Our live one-day session downloads the skills and strategies necessary to identify, protect, and manage your intellectual property so that you develop a worthwhile legacy. You will receive a step-by-step instruction workbook, live instruction from yours truly, and time to ask questions. Sign up for the webinar now at the link or leave your email to receive upcoming webinar dates, discounts, and more.
All right, guys. So the next one is going to be taking place on May 22nd, which is a Saturday at 6 p.m. And I will make sure I leave a link in the description box so you will know when that when you can actually purchase that course. But you have all of the information that you need, where you're going to be learning the trademark process from beginning to end, and see what I do day in and day out as a trademark attorney. But we are getting ready for our next segment, which is what's happening in these IP streets with Mackenzie. Make sure that you subscribe. Share this YouTube channel with your friends if they have questions about IP. We created this channel with the hopes that everyone has a basic understanding of intellectual property. Even if you're someone who doesn't necessarily have a business, this is important information that you can use to understand what is the purpose of trademarks and intellectual property in general, and how it impacts our daily lives. So I hope you guys enjoy. And we are going to get ready to talk about what's happening in these IP streets with Mackenzie. So what is happening in these IP streets?
Look, man, let's start off with this Zittles, I think is how you pronounce it. Okay.
Yeah. Okay.
So Zittles is the company who makes Zittles, does THC, paraphernalia, infused candies, products in general, promotional things. And so they had taken Skittles' mark completely. Wrigley filed a suit, 63-page long filing. And Mr. Wrigley said, I've created this mark for over 50 years. And, here comes this brand, and it's completely not, with their scope of products, and completely takes the mark, changes the first and the last letter, and files for trademark infringement.
So on our next episode, which is going to be episode 5, the technical file we're going to be talking about is if it's popular, if it's famous, stay away from it. Because I feel like, for instance, obviously their names is what did it say it again? Pronounce it.
Instead of Skittles with an S at the end and S at the beginning, it's a Z instead of a
Z. Got it. So obviously, we recognize that this company is biting on the goodwill parody of Skittles, right? For the candy. Skittles has been around for years, right? And obviously, we know that this is not associated with Skittles, but because a lot of times they're using the same packaging, even though they're not in the same genre, but I'm assuming it's some type of edible. Is that what it is?
It's basically the candy, but completely taken out with THC infused candy inside.
Gotcha. So I imagine it's not going to be sold in our regular stores. It's going to be sold in some type of dispensary, your typical smoke shops, those types of stores. But the point is they got that name from somewhere. They're obviously biting on the goodwill that Skittles has put into that brand. And I'm assuming they're owned by M&M Company, but don't quote me. But I find that a lot of companies do this. They find that they think they're being funny, and really you're diluting the strength of this particular brand. We see it all the time. It's like we talked about with Starbucks, where Starbucks stopped a lady from doing Starbucks for dog hotels, because you're basically doing a play on words from what you heard from Starbucks and decided you want to make it for dog hotels. So the same thing in this instance, where I can see why Skittles would not want to be associated with this, because obviously this is a candy that a ton of kids love. It's a family-oriented type of candy. So they don't want any association with this. But I see this all the time where, again, I follow a couple different people on Twitter that go on to the USPTO and look for marks that are basically biting on the goodwill of other major marks. Like we've seen some for Nike copying, where again, people just don't understand what the purpose of a trademark is, and how you're being influenced by other trademarks. And you think, well, if I'm doing it in something completely different, then I don't have to worry about them coming after me. But there's also a theory called trademark dilution. And so with trademark dilution, you dilute the strength of a famous mark. This is only for famous marks. So I feel like this is what's going to end up happening with this mark, and they're probably going to lose in this case. But I guess in our next case that we have, it's going to be completely different.
Well, that dilution is actually the key term in this. So it's funny that you said that. It's dilution and infringement of their mark. They're suing for millions in damages, obviously to terminate that Zittles, I guess is how you pronounce it. They're
Right.
all on promotion and have a permanent injunction. So
Gotcha. So I'm assuming they actually received registration on the USPTO. I'm going to look more into that, which is very interesting, because I would think that, again, they would say that this is too close to that mark. And a lot of times when it comes to certain, with the analysis that they look at, and determining whether or not there's a likelihood of confusion, it's a case-by-case basis. So a lot of times where I don't think they're going to come back with a likelihood of confusion, they do. So again, it's a case-by-case basis. So I'm like, really? You made that reach? But okay, fine. It's really interesting, especially if, for instance, again, when you pick a protection class, it's very broad, the numbers, and how many different things can be under one class. So a lot of times you think your client is safe if what they're doing is completely different from what maybe another competitor is doing. Right. But again, completely unrelated. So it just depends on who you get as far as your examining attorney is, to be completely honest with you. Again, there's the DuPont factors, which we will talk about in another episode. But it is on a case-by-case basis as how they determine where there's a likelihood of confusion. So I am looking forward to seeing how this case plays out. Again, this is the whole point, to stand out, to not try to always bite on the goodwill that other companies have put out there as far as Skittles is concerned. Because Skittles has been around since we were, kids? Long time. Yeah. And we cuss on this podcast or on this YouTube channel. So,
So I know you've been looking at the Chanel versus, I may say this incorrectly, but I think it's Huawei. It's right. Huawei.
It's Huawei.
Yeah. So Chanel is not happy that the Chinese brand Huawei is, in their perspective, similar enough to possibly cause confusion to their brand, their traditional logo that they've had. It was dismissed. The complaint that was filed was dismissed in the General Court of the European Union, which is in Luxembourg, and they said that they were dissimilar marks, and that just having a geometric circle is not enough to basically say that you're going to cause confusion. And if you look at the pictures themselves, I think it was a little bit of a stretch too.
I think it was a bit of a stretch too. Again, this is another trademark dilution case, because obviously Chanel. Okay, so obviously this is the Chanel mark, and then if you can show the. Yep. I mean, completely different. And again, these are completely unrelated products and services. So the Huawei company is what techie based, basically, and obviously Chanel is still all things luxury and fashion. So in this case, they're arguing more of a trademark dilution standing than actual infringement on the exact same protection class. So again, this is something that is only for famous marks, but this is a reach here. Mind you, it's interlocking. They look more like U's, and theirs is interlocking C's, right? So I just feel like that is a stretch. And Chanel, obviously being by one of the bigger brands, they're very litigious, like McDonald's, who went after a company in Michigan for Mickey D's. And interestingly enough, Mickey D's is an unofficial name. It was never a name that they actually had a registration for. It's just something that we as the consumers were saying. But they still tried to stop this particular Michigan Coney Island style company from operating restaurants across Michigan, and they lost that battle. But a lot of times I think they are just trying to intimidate these companies simply as a battle of money.
Right.
So I just think that they weren't prepared that this company was willing to fight. But, you know, once you file a lawsuit, you just got to go through with it, right?
Right.
But they smack their hands because, again, I get fighting for your marks, you know, for as ferociously as you want. But sometimes you have to just kind of look and say, you know what, this is a reach. We need to just let this go.
Right.
So, yeah, I agree with how that case turned out. What
do you think about the Kanye West and Walmart?
All right, so that takes us to our next argument or case for the night. This one is interesting to me because, again, this is another trademark dilution case because Walmart sells shoes, but to think that anyone is going to confuse Kanye West's mark with Walmart's mark, which I didn't know it was an official mark, is a reach. So I'm going to assume the one on the right is the Walmart mark, correct? And then the one on the left is the Kanye mark?
Yes, the thicker lines is the Walmart mark with the 6 lines, which is a sun, both depict a sun. And then the one with the dots and the 8 lines is Kanye West for Yeezy.
Got it. And see, the other issue there is the Walmart mark is not on their shoes. Even though they sell shoes, it's not, if I'm not mistaken anyway, it's not on the brand of the shoes. Whereas with Kanye West, his mark is on shoes and clothing, I imagine. It's just on, you know, clothing and those things. So this is a reach for me, in my opinion. Obviously, you never know what the USPTO or the courts are going to do. Sometimes they really shock the shit out of me. So who knows how this is going to play out.
Yeah, it looks like Walmart's been having this mark since 2007, and Kanye just applied since 2020 for this mark. So I don't think, Walmart is saying they're confusingly similar, and I just don't agree. I mean, on top of that, when you see Yeezys, if you think Walmart,
first of all, you're not buying no Yeezys. So there's another legal term where they say that the public is intelligent enough to know the difference. If I'm buying Yeezys, which I'm probably waiting in line with 500 other idiots, I'm sorry, not idiots, but 500 other shoe enthusiasts, including my boyfriend, I'm spending thousands of dollars for shoes. Okay.
Right.
So I'm not confusing that with Walmart, which the shoe might be $20.
No.
Really, Walmart?
The lines are different too. Like even in the actual marks, you know, you've got the dots, the kind of like perforated looking lines. You've got 8 of those in the shit. I think Walmart really just is upset that it's a sun, to be honest with you. Because if I don't know. I just like the Chanel, to me, in my opinion, it's dissimilar.
It's a reach. But I just think they want to, again, let people know that we're very litigious. So we'll go after stuff even if we don't think we're going to win. So if you get something that's close, even remotely close, we coming after that ass. That's all. That's what I think.
How do you think Kanye feels like Walmart's after him?
I don't really know what Kanye thinks, to be honest with you, because right now Kanye got other fish to fry. You know what I'm saying?
Right.
He trying to get through this divorce and, you know, make sure that he can stay in Wyoming with the kids. I really don't think he cares. He handle that, lawyers. He might put it in the song.
He probably will.
I think he will find it in the song. But now that I think about it, I actually plan to go in Walmart and just see if the mark is on shoes? I'm just kind of curious because I don't think
on the bottom.
Maybe. But I mean, is it great value? Or is it the mark? Because I literally feel like the mark is just on like the outside of the stores. It has nothing to do with the shoes or like any of their actual products in the store.
Do you think any of the same terms or similar terms as far as dilution and, confusingly similar? Do you think that, Walmart's going to have a case?
They're going to try. That's their strongest argument. But again, the public is smart enough to know the difference between Kanye West and Walmart. Y'all not in the same lines.
Right.
Y'all just not. Right. If you buying shoes from Walmart, you're not in the line for Yeezys. You're not. Right. You're just not. Even if you didn't necessarily buy the shoes from a legit seller, you are not in the same line.
You're not.
You're just not. You are absolutely not.
I'm not expecting the same product. I think it's almost like, besides the fact, I can see Kanye saying how, thinking that the products would be similar or the marks would be similar could almost be kind of insulting. You know what I'm saying? Only because he's in his, field as a, maybe like a haute couture type designer,
exactly.
To high fashion. And then you got Walmart.
Like, really? Honestly, I can't wait to see if he puts this in a song because I just want to see how he slaps that hand. Like, Walmart thought it was in the same lane as me. Like, what?
It's just too bad that he's not allowed to tweet, during a case about the case, because I just feel like,
when does that ever stop Kanye?
You're right, but you would think the rules.
If he really wanted to say something, he would. But I just think right now Kanye has other things going on that this is not even on his radar to even give a fuck about, to be completely honest with you. But I find it interesting that all three of these cases are cases of trademark dilution. It's not exact likelihood of confusion because they're completely unrelated products for the most part. I don't think the Walmart mark is on shoes, but I'm going to double check. I just think it's in relation to the retail of the store, Walmart, right? The Chanel case, we're talking about technology versus Chanel. Obviously, Chanel is clothing, perfumes, all things fashion, or, those types of things. They're never expanding into technology that I'm aware of anyway.
Right.
So they're arguing more so trademark dilution than anything. The other case, which was same thing, where they're biting on the goodwill of Skittles. I don't think Skittles is ever planning to sell edibles in that realm. And that they're, again, so the whole point for new companies coming into this business is to understand that, or to any type of business that you want to start, is don't bite on the goodwill of another company simply because you think it's unrelated to what they do. Start from fresh. You want to start where you tell the story of why your brand should get support from whoever your target audience is, because then these other companies will have a reason to come after you. And a lot of times it's just a will of money. And if you don't have the budget to fight it, it's not worth the time.
Right.
Because when there isn't an overlap, you see what happens. Right? So thank you guys for joining us for another episode of Blow the Whistle with EJLee Law and Mackenzie. This is what's happening in the IP streets. We're going to do a live episode soon where we're going to be taking your questions about what's going on in the IP streets. And just if you have questions about any IP related questions for whether it's from copyright or from trademark, this is the time to ask them, because any other time you would have to book a consultation. And so we look forward to talking to you guys soon in our next episode, where we're going to be talking about limited mindsets. Again, if it's popular, avoid it. There's a reason why it's popular. They've done the work. So it's your job to do the work in creating unique brands that stand out and that can be associated with you only. And so we will catch you guys on the next episode. Bye.
Bye.